guys, welcome back to my channel Grab Your Notes. This is Reshna sharing my handwritten notes. Today we are going to discuss about the topic foreign judgment. So let's get started.
Foreign judgment is a judgment of a foreign court, meaning Section 2 subclause 6 defines the foreign judgment as a judgment of a foreign court. The term foreign court has been defined in Section 2 subclause 5 as a court situate outside India and not established or continued by the authority of central government. The examples of foreign court are the court in England, Pakistan, Ceylon, etc. Now let's get into the object of foreign judgment. The judgment of a foreign court is enforced on the principle that where a court of competent jurisdiction has adjudicated upon a claim, a legal obligation arises to satisfy that claim. Section 13 embodies the principle of res judicata in foreign judgments. For example, A sues B in a foreign court. The suit is dismissed. The judgment will operate as a bar to a fresh suit by A against B in India on the same cause of action. Now let's discuss its conclusive nature. Section 13 of the Code provides that a foreign judgment shall be conclusive as to any matter thereby directly adjudicated upon between same parties or parties whom they or any of them claim litigating under the same title, except as specified in clauses A to F of Section 13. Now we are going to discuss about under what circumstances when a foreign judgment would not be considered as binding in a court. According to Section 13, under the following 6 cases, a foreign judgment shall not be conclusive. Number 1. Foreign judgment not by a competent court. Number 2. Foreign judgment not on merits. Number 3. Foreign judgment against international or Indian law. Number 4. Foreign judgment opposed to natural justice. Number 5. Foreign judgment obtained by fraud. Number 6. Foreign judgment found on a breach of Indian law. Now let's discuss each of those cases in detail. Number 1 was foreign judgment not by competent court. A foreign judgment must be pronounced by a court of competent jurisdiction and must be by a court competent by the law of the state which has constituted it and in an international sense. And also it must have directly adjudicated upon the matter which pleaded as res judicata. Only the judgment and not the reasons for the judgment is conclusive. And the second case was foreign judgment not on merits. A judgment is said to be given on merits when, after taking evidence and application of mind, the judge decides the case one way or the other. But the dismissal of suit for default of appearance or non-production of the document by the plaintiff or passing of decree due to default of defendant in furnishing security are not on merits and cannot be conclusive. And the third case was foreign judgment against international or Indian law. The mistake of international or Indian law must be apparent on the face of the proceedings. Now let's discuss a case regarding it. Narasimha Rao vs. Venkatalakshmi 1991. In this case, the court held that when a foreign judgment is founded on a jurisdiction or on a ground that is not recognized by international or Indian law, it is a judgment which is in defiance of the law. Hence, it is not conclusive of the matter adjudicated therein. Therefore, it is not enforceable in this country. And the next case was foreign judgment opposed to natural justice. The judgment pronounced by a foreign court must be after the observation of the judicial process. That is, that the court rendering the judgment must observe the minimum requirements of natural justice. Which means that the judgment to be conclusive must be composed of impartial persons acting fairly without bias and in good faith. It must give reasonable notice to the parties to the dispute and afford each party adequate opportunity of presenting his case. And the fifth case was foreign judgment obtained by fraud. It is a fundamental principle of private international law that if a foreign judgment is obtained by fraud, it will not operate as res judicata. It is the settled proposition of law that a judgment or a decree obtained by playing fraud on the court is a nullity and non-est in the eye of law. And the last and sixth case was foreign judgment founded on breach of Indian law. It is implicit that foreign law and foreign judgment should not offend against our public policy. Thus, a foreign judgment for a gambling debt or on a claim which is barred under the law of limitation in India is not conclusive. Now let's enter into the topic presumption as to foreign judgments. Section 14 provides that the court shall presume upon the production of any document purporting to be certified copy of the foreign judgment that such judgment was pronounced by a court of competent jurisdiction unless contrary appears on the record. But such presumptions may be displaced by proving want of jurisdiction. Now let's enter into the last topic of the video, enforcement of foreign judgments. A conclusive judgment under Section 13 can be enforced in India in the following two ways. Number 1, by instituting a suit on such foreign judgment. A foreign judgment may be enforced by institution of a suit within a period of 3 years from the date of the foreign judgment. In the case of Roshan Lal versus Mohan Singh 1975, the Apex Court had held that any decision of a foreign court, tribunal or quasi-judicial authority is not enforceable in a country unless such decision is embodied in a decree of a court of that country. And the second way is that by institution of executing proceedings. A foreign judgment may be enforced by way of execution proceedings as per specified under Section 44A of the Code and where all conditions of Section 13 subclause A to subclause F are satisfied. That's all for today. Let's continue in the next video. Happy learning, guys!